Andrea Lewis is a trial attorney and former felony prosecutor. She is joining us now live to talk much more about all of this. And Andrea, there are a lot of questions about the significance of this and what it really does mean. So first off, thank you so much for taking the time to be here.
Thanks for having me.
Of course. And can a suspect, this is the big question, can a suspect simply refuse to appear virtually?
That's a great question. So first of all, let's talk about what it means to appear virtually. This was really a foreign concept to a large degree prior to COVID-19. But since that time, things have really changed in the court setting. And these types of virtual, most of the time Zoom appearances by defendants in criminal cases have become a lot more common. And so most courts will allow this. Like I said, it has sort of become routine depending on the court and depending on the type of hearing. Obviously, some hearings requiring a lot of evidence or participation from the defendant may need to be in person, but it'll depend on the various rules in the jurisdiction. I've seen many courts often require that the defendant give consent in order to hold a hearing virtually as opposed to in person.
What does it mean to say the Pennsylvania case is, quote unquote, on hold? Under what, let's say, circumstances can a court legitimately pause or even delay the proceedings?
This is not as uncommon as it seems. So many times when criminal defendants like this one have have multiple cases in various jurisdictions that are all gearing up for trial, what the court will do is stay the prosecution in one or more of the jurisdictions to allow the defendant to complete the trial, resolve a case, be sentenced in one jurisdiction prior to moving everything to another so he can face those charges there. So that's not on its face unusual. This is often occurs when a defendant's in custody somewhere else, or like I said, when they have several different cases occurring in various places.
What is maybe the defense's argument there on why he should not appear virtually? What sort of significance does it hold? What benefit for the defense to say, we need to put this case on hold because he doesn't want to be there virtually?
Generally speaking, what the defense argues and it says, hey, listen, judge, this is a very serious case. My client's life and liberty is hanging in the balance. So we need to be there in person to address the charges, to hold the hearing, to have evidence if necessary, put things into evidence and things of that nature. Now, in reality, though, there are a variety of reasons why a defendant might want this that has nothing to do with those things. For instance, it has the ability to delay the proceedings, frankly, potentially in both jurisdictions, right? So if he's in Pennsylvania, his other charges it's going to be difficult for them to move that forward. So it causes delays. Of course, Luigi is going to say that he needs to adequately prepare for the prosecution in both places. So he needs to be present in the jurisdiction to do that. Regardless of the reason why they're stating they need this, the fact of the matter is the judge is going to look at it, determine whether the request is reasonable, whether his due process rights are being violated or not, and then make a determination on how the hearing will be held.
And I did want to ask you, because the federal case is likely to go through first, federal and state over in New York, and then obviously the Pennsylvania case is kind of off in the distance there. Does the outcome of what we see in the federal and state case in New York have any sort of impact or influence on what does happen in Pennsylvania?
Absolutely. There's many ways. Number one, admissions or testimony in the trial could come in. Whether there's a conviction, that of course could affect the outcome in Pennsylvania in terms of sentencing, or what charges the Pennsylvania prosecutor ultimately goes forward with. It's not uncommon at all. We've all seen this many times where someone is facing serious charges in one jurisdiction. Maybe they get sentenced to life in prison or some other, very serious sanction. And then other jurisdictions that may have lesser charges, they either just plead them out to concurrent jail time, or take other action that would allow them to just resolve all the cases without the need for another long trial.
All right. Andrea Lewis, as always, thank you so much for taking the time to join us. Anything we missed? Anything you want to add here before I let you go?
I don't think so. This case, I do think that the resolution and the outcome of the federal case is going to be determinative on what happens in a lot of these other jurisdictions. As we all know, the evidence here is very strong. And so in the event that the federal government gets the conviction that they're seeking, and it looks like they probably will, I think that some of these other charges that we're talking about here today will resolve on their own.
All right. Andrea Lewis, thank you again for being here with us. We definitely appreciate it.
Thank you. Bye.